This presentation builds upon the lessons found in my text, Fundamental Trial Advocacy and Fundamental Pretrial Advocacy, a strategic guide to effective litigation that was written with Professor Jim Underwood at Baylor College of Law. The following slides lay out the basic issues present when beginning a deposition. You should review these slides and then listen to the example provided in this video. This process will allow you to see persuasive skills in action. As you listen to the advocate questioning the witness, ask yourself why they're doing what they are doing in this particular fashion. When you can see that answer, when you understand the connections, you will be taking a very large step along your own path to having the ability to do the same thing when you take depositions. Remember, the deposition process is designed to get commitments from the witness, to explore theories that may be out there, and to discover information that we don't yet know. Admonitions ensure that whatever answers we get from the witness are ones that we can rely on. It's a lot like putting the witness in the proper position to ensure that their testimony is relevant, admissible, and ironclad at trial. Let's take a look at this example and see how well it works. Attorney for Ms. Hartwell.
Good morning.
Good morning. I've got several questions that I need to ask you today, but before we do, I need to make certain that we all understand what's going on in these proceedings. Okay? All right. Ma'am, the first thing that I would do is ask you to speak up sufficiently that the camera can hear you, because the only thing worse than doing a deposition would be to do two depositions because it wasn't recorded the first time.
Yeah, I understand. Thank you.
I understand. The court reporter, can we hear her voice now on the camera?
Yes.
All right, thank you. Ma'am, we're here in my law offices today because of the suit that you have filed against my client. You understand that?
Yes.
All right. And under the law, we have an opportunity to ask questions of folks to make certain that we can sort out what should be done.
I understand.
Right, and that's what I'm going to do today. I'm going to ask questions.
Okay.
And I'm going to need you to answer those questions.
Yes.
And can we agree that you'll do that?
Yes, absolutely.
Thank you. Now, as you answer those questions, because we're recording it, and because we want to make certain there's not any confusion, if we could, be clear with yes or no, and not just shake, nod our heads or shake our heads or say uh-huh or uh-huh. Can we agree that we do that today?
Yes, I understand.
Thank you, ma'am. And I know that you understand, but will you also agree to do that?
Oh, yes, I do.
Thank you, ma'am. Now, you just took an oath with the court reporter. Do you understand what that oath means?
Yes.
And what does it mean to you?
It means that I swear to tell the truth.
Okay. And can we agree that you'll do that today?
Yes.
Now, would you agree with me that the truth is best when it's the complete truth?
Yes.
When it's the whole truth?
Yes.
And when it's fair?
Yes.
And when it's complete?
Yes.
And will you, in answering my questions today, give me full, fair, and complete answers?
Yes, I will.
All right. And will you let me know if there's anything else that you want to add?
Yes.
All right, thank you. Now, after the deposition is taken, a copy of it will be provided to your attorney's office, and you'll be given an opportunity to review it. Did you know that?
No, I didn't, but yes, that's good.
Now, would you promise us that you'll look at it?
Yes.
And you'll listen to it?
Yes.
And if there's anything in it that you believe to be incorrect, you'll make a correction?
Absolutely.
And you'll let us know?
Yes.
So that I can rely upon the things that you say today to be a fair and accurate assessment or accounting for what's happened.
Okay.
Okay, and we'll do that?
Yes.
All right, ma'am. I wanted to make certain that that was the case before we proceeded. Now, you'll have the ability during this deposition to take a break if you need to.
Okay.
Whether for comfort, get something to eat, something to drink, just to catch your breath. What I ask, though, is that you let me know when you want to take a break.
Okay.
And we'll take that break. But if there's a question that's waiting to be answered, can you agree with me that it would probably be best for you to answer that question before we take the break?
Yes.
Because otherwise someone might think that someone had given you the answer during the break, and that wouldn't be fair, would it?
No, it would not.
It wouldn't be fair to you?
No.
And it wouldn't be fair to Ms. Hartwell?
No.
Okay. I wanted to make certain that we understood that. Ma'am, I know this has been a very difficult time for you.
It has.
A lot of times when folks lose a child or a loved one, they get some help to deal with it emotionally. I don't want to inquire into your personal medical history or into any type of counseling that you may or may not have received. But I do need to know, for purposes of this deposition, whether or not you might be taking any medication that might affect your ability to answer the questions or the way you appear on camera today. Are there any medications that have been prescribed for you that the doctor has told you might do that?
I'm not under any medication right now.
Okay, so you're not taking any medication?
No,
All right, thank you.
currently.
And then I also have to ask, just to make certain that your testimony is good, have you had any controlled substance, either alcohol or otherwise, in the last 12 hours that might affect your ability to answer these questions?
No, I have not.
You have not, okay. Now, ma'am, when you came today, did you come from your new home that you guys recently built?
Yes.
Now, you should notice from having watched this particular set of admonitions that the attorney involved, you may recognize his voice, is trying to deal with a very sympathetic lady who's lost multiple children in a horrible car accident. Now, this woman may be at least partially at fault, but the attorney's got to set her up so that he can rely upon the answers that she's going to give. Now, the way that you do that is you look at those issues that might create a problem. You need to make certain that they understand the meaning of the oath, that they agree to give a full, fair, and complete answer to your question, that they won't talk to their attorney when a question is pending, that they'll let you know if they need to take a break, that they understand the purpose of the deposition, and that they'll review the deposition after the fact and make any appropriate corrections to the record. What you want to do through the use of the admonitions is prevent them from saying at trial, well, you didn't ask me that question, or I didn't understand, or I was taking medication, I wasn't ready. All those sorts of excuses that come up, admonitions are designed to prevent them from being effective in the eyes of the jury. In order for that to work, though, you've got to ask those questions in a way that doesn't offend the witness, but rather places them at ease and helps them to understand their place in the process and the reason that you're doing what you're doing. When handled properly, they can be a thing of beauty. So we've looked at admonitions. In other podcasts, you'll get an opportunity to see some theory testing and some development of questions and use of documents. For now, I'm going to let you guys go. Have a good time wherever you are, and we'll see you when we see you. This is Charles Rose. Talk to you later. Take care. Bye.